Hi guys, welcome to Unacademy. Wait for a second, there has been some problem with the live streaming. Give me a minute or two, I'll get it fixed. So guys, a warm welcome to Unacademy and a warm welcome to my special class, perhaps a YouTube session on important polity current affairs MCQs for your prelims on June 2nd, 2019. So this is me, Rangu Satish, one of your favorite educator on the platform. So ladies and gentlemen, I do have created many lessons on Unacademy free platform where you can access more than 1500 videos by installing app known as Unacademy Learning app and search for my name here, Rangu Satish. You will get more than 1500 lessons of mine over there. So ladies and gentlemen, we do have this Unacademy Plus subscription nowadays, so you can subscribe either for 6 months or for the 1 year one. And please do use my referral code, that is Rangu Satish 1947, for getting the 10% discount. So ladies and gentlemen, coming to our course, we had already discussed five lessons regarding the polity current affairs through MCQs. The first one was scheduled on 1st March, then 3rd March, then 5th March, then 7th March, then 9th March, and this is the 6th one, which is the concluding one of this particular course. So ladies and gentlemen, here we are going to discuss a couple of few questions. Okay, so let us discuss all these questions bearing in the mind our prelims, which is scheduled on June 2nd, 2019. So coming to the first question, the doctrine of progressive realization of rights and non-retrogression was introduced by the Supreme Court in a case relating to Section 377 of IPC, privacy as a fundamental right, electoral reforms, and euthanasia. So ladies and gentlemen, uh, here the answer is A, that is Section 377 of IPC. As you all know, recently the Supreme Court of India delivered the judgment regarding Section 377 of IPC. They had struck down this particular section and given certain freedom to the LGBT community. So ladies and gentlemen, as part of it, they have propounded two new theories, that is the doctrine of progressive realization of rights and non-retrogression. So the doctrine of progressive realization of rights means the rights will have to be evolved as the time progress, the one which it says. So as we do evolve in our thinking, in our maturity, and the time progress, we do have to come over the boundaries we have drawn earlier. So here the LGBT community requirements have been understood by the Supreme Court of India and gave the freedom to them for their consensual sex. So here, coming to the term non-retrogression, that means that once the rights are given, cannot be taken back by the progressive governments. So here the Supreme Court of India has struck down this Section 377 of IPC, and it cannot be reintroduced in the future times. That is what is being called as non-retrogression. Okay, so ladies and gentlemen, here I'll be a bit louder, ladies and gentlemen. I'll be a bit louder. There has been some problem with the app here, with the software here. I will be a bit louder. By that, everything will be clear to you. Okay. So moving on to another important question, the Navtej Singh Johar versus Union of India case recently in the news is related to Triple Talaq, Section 377 of IPC, Uniform Civil Code, criminal defamation of IPC. Please do let me know your answer in the comment box. I do give 30 seconds for this question. Exactly right. The answer here is B, that is section 377 of IPC. I do really appreciate the people who have written their answers in the comment box. So ladies and gentlemen, Navtej Singh Johar versus Union of India case is indeed related to the section 377 of IPC, in which the Supreme Court of India had delivered its judgment, in which they had struck down section 377 of IPC. Okay, so moving on to another important question, perhaps the most important question among all other questions being posted here. D voters recently in the news belong to a category of voters who are declared a foreigner by special tribunals under the Foreigners Act, whose names have not been included in the National Register of Citizens, who lack proper citizenship document and have been disenfranchised by the government. Option D, none of the above. So ladies and gentlemen, I will give you 30 seconds of the time to answer this question. Here the answer is C, ladies and gentlemen, that is D voters, who are also called as doubtful voters, are the people who lack proper citizenship document and have been disenfranchised by the government. So ladies and gentlemen, D voters are usually the one who have got into India on illegal immigration. As you all know, we do have certain porous borders with Bangladesh and Myanmar. So people do come to India through these borders, and they do settle in some part of northeastern states. So you do find many of those illegal migrants in Assam. Hence the government of India has introduced NRC. So here D voters are those voters who have acquired their citizenship of the country by illegal means. Hence they have been disenfranchised. That means they have been removed from the electoral rolls to exercise their universal adult franchise. So here is an explanation. Who is a D voter? D voter stands for dubious or doubtful. This is a category of voters disenfranchised by the government for alleged lack of proper citizenship document. Some 2.48 lakh people got the D voters tag during the NRC process. So ladies and gentlemen, these are the illegal migrants who have come to India from Myanmar and Bangladesh, who have got settled in Assam. Hence they have been considered as doubtful voters. Hence their voting rights has been taken back by the government of India. So moving on to another important question. Consider the following statement about Article 35A. Recently in the news, it is a provision incorporated in the Constitution of Jammu and Kashmir. It enables the Jammu and Kashmir legislature to decide who all are the state's permanent residents and confer on them special rights and privileges. No act of the Jammu and Kashmir legislature coming under the Article 35A can be challenged for violating the Indian Constitution or any other law of the land. Which of the following statement given above is correct? Option A 1 and 2, option B 2 and 2 only, option C 2 and 3, Option D, 3 only. So ladies and gentlemen, I'll give you 30 seconds of time to answer this question. So ladies and gentlemen, the answer here is C, as one of the aspirants have put out here. So the answer is 2 and 3. So coming to the explanation, it is a provision incorporated in the Constitution of Jammu and Kashmir. This particular statement is absolutely wrong because Article 35A has been incorporated in the Constitution of India rather than in the Constitution of Jammu and Kashmir. So ladies and gentlemen, let us look at the explanation of this Article 35A. Okay. So what is Article 35A? It is a provision incorporated in the Constitution through a presidential order and not by parliamentary debate, giving the Jammu and Kashmir state legislature a complete say in deciding who the permanent residents of the state are. So the state legislature can grant its permanent residents special rights and privileges in public sector jobs, acquisition of property, scholarship and other public aid and welfare programs within the state. So ladies and gentlemen, Article 35A says that the Jammu and Kashmir legislature has complete power to decide who is a permanent resident of the state and who is not a permanent resident of the state, and also they can decide upon the privileges to be given to the permanent residents of the state over there, and they can also decide who can acquire the property over there and who cannot acquire the property over there. So do with the scholarship given there. So how did article come about is a question which you have to ask. So it was incorporated into the Constitution in 1954 by an order of President Rajendra Prasad on the advice of Mr. Nehru. The Constitution Order of 1954 followed the 1952 Delhi Agreement entered into between Prime Minister Nehru and Jammu and Kashmir Minister Sheikh Abdullah, extending Indian citizenship to the state subjects of Jammu and Kashmir. Article 35A was added to the Constitution as a testimony of special consideration the Indian government accorded the permanent residents of Jammu and Kashmir. So ladies and gentlemen, here the point to be noted is that to insert Article 35A, there had not been any constitutional amendment as such. It was added into the Indian Constitution by a presidential order which was issued in 1954. Okay, hence there had been a public interest litigation filed in this regard. The litigation says that Article 368 of the Indian Constitution says that anything can be added to the Indian Constitution by constitutional amendment. However, in inserting Article 35A into the Indian Constitution, there had not been any amendment to the Indian Constitution. Hence, the article to be struck down, what the public interest litigation says. So, the presidential order was issued under Article 371D, which allows the president to make certain exceptions and modifications to the Constitution for the benefit of Jammu and Kashmir. However, Article 368 of the Constitution mandates that only the Parliament can amend the Constitution by introducing a new article, as the explanation I have given already. Moving on to another important question, that is a follow-up question to the earlier question. Article 35A was incorporated into the Indian Constitution by a presidential order, a constitutional amendment, the Constituent Assembly, a Supreme Court order. So here the answer is A, ladies and gentlemen, that is presidential order, what we had discussed earlier. So this has led to the protest across the country right now. There had been a public interest litigation in this regard to strike down Article 35A, which had been inserted without following the due procedure established by law. Moving on to another important question. The President of India may by public notification declare that Article 370 shall cease to be operative from such date as he may specify, provided that it shall be necessary for the President to have received prior recommendation of the Governor General of India, the Constituent Assembly of Jammu and Kashmir, the Legislative Assembly of Jammu and Kashmir, the Governor of Jammu and Kashmir. I am giving you 30 seconds of the time to answer this question. So ladies and gentlemen, answer here is B. That is the Constituent Assembly of Jammu and Kashmir. So ladies and gentlemen, Article 370 can be removed from the Indian Constitution only if the Constituent Assembly of Jammu and Kashmir gives assent to it. That is a point to be discussed here. However, the Constituent Assembly of Jammu and Kashmir had been dissolved right after the commencement of the Constitution of Jammu and Kashmir. So what is the point of giving the assent by the Constituent Assembly here is a question which was asked in the public interest litigation filed in Supreme Court of India. So a petition has been filed in the Supreme Court challenging the continued existence of Article 370, which gives a temporary autonomous status to the state of Jammu and Kashmir and restricts the power to make laws for the state. So ladies and gentlemen, Article 370 gives huge amount of autonomy to the Jammu and Kashmir in terms of their administration. So take for example, if the law is made by the parliament that would not be applicable to the Jammu and Kashmir by default, the concurrence or the opinion of Jammu and Kashmir legislature is required in order to roll out the government scheme over there. So that is what we call as autonomous status given to the Jammu and Kashmir. So the petition especially challenges a particular provision in Article 370 which mandates that the President should first get the permission of the Constituent Assembly of the state of Jammu and Kashmir before declaring the article null and void. But where do we have the Constituent Assembly of Jammu and Kashmir now? We do not have any Constituent Assembly of Jammu and Kashmir now because it had been dissolved already by the Assembly of Jammu and Kashmir right after the commencement of the Constitution of Jammu and Kashmir. So moving on to another important question, that is, consider the following statement. The President and the Governor can pardon, reprieve, respite, remit, suspend or commute the sentence or punishment of any person convicted of any offence against a central and state law respectively. The President is the only authority who can pardon a death sentence. Which of the following statements given above are correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, and option D, neither 1 nor 2. I'm giving you 1 minute of time to do this question. This is one of the toughest questions to be given here. Please do it by yourself. So ladies and gentlemen, the answer here is C, that is both 1 and 2 statements are absolutely correct. Okay. So coming to the explanation. Comparing pardoning power of the President and Governor is of high importance because recently the Tamil Nadu state legislature had passed a resolution to protect the perpetrators of Rajiv Gandhi assassinations case from death sentence. So here the state legislature of Tamil Nadu government had passed a resolution to ask the governor of the state to pardon the perpetrators from the death sentence. So this might be a political move being done by the Tamil Nadu running government. So comparing pardoning power of the president and governor is of high importance right now. Whether to know whether the governor has the pardoning power when it comes to a death sentence or not is the question. So president, he can pardon, reprieve, respite, remit, suspend or commute the punishment or sentence of any person convicted of any offense against a central law. So whereas the governor can do all of it when it comes to the state law. Okay, so president can do all of it when it comes to the central law, that is a union law, whereas the governor can do the same in case of the state law. So that is a major difference. Another one is he can pardon, reprieve, respite, remit, suspend or commute a death sentence. He is the only authority to pardon a death sentence. So ladies and gentlemen, it is the discretion of the president to pardon a death sentence, and which has not been given to the governor of the state. Hence the resolution being passed by the Tamil Nadu government might not do the job. So he can grant pardon, reprieve, respite, suspension, remission or commutation in respect to punishment or sentence by a court martial. So he does not possess any such power. So when it comes to the martial law or the military court, then the President of India would have the power to exercise his pardoning powers. However, there have not been given any power to the governor of the state to deal with any of the military law or military courts, what we call as martial courts. Moving on to another important question, that is Shamsher Singh case. Sometimes in the news is related to speaker's powers under the anti-defection law, discretionary powers of the governor, Supreme Court's advisory jurisdiction under Article 143, scope of Article 32. So ladies and gentlemen, please do let me know the answer in 30 seconds. So here the answer is B, ladies and gentlemen, that is discretionary powers of the governor. So Shamsher Singh case is considered to be one of the landmark case which details out the discretionary powers of the governor. So what are the discretionary powers of the governors? The powers which can be exercised by the governor without the aid and advice of the State Council of Ministers is called as discretionary powers. Okay, so let us look at the explanation here. So in the view of the Supreme Court, speaking through a 5-judge bench in Nabam Rabia and Bamang Felix versus Deputy Speaker, the discretionary power of the governor is extremely limited and entirely amendable to the judicial review. So time and again the courts have spoken out against the governor acting in the capacity of all pervading super constitutional authority. Even when the exercise of discretion is concerned, a 7-judge bench of the apex court in Shamsher Singh versus State of Punjab had held that the governor may do so only in harmony with Council of Ministers. To do so, the governor is precluded from taking a stand against the wishes of the Council of Ministers. So ladies and gentlemen, as you all know, India follows the parliamentary form of government, where the Prime Minister and Council of Ministers would aid and advise the President of India. So do with the state, where the governor is aided and advised by the State Council of Ministers. So here, however, the governor and the President of India have been given certain discretionary powers. Despite of that, the discretionary powers can be exercised by these two authorities only in consonance with the opinion of the Council of Ministers. The point to be noted. If the governor do exercise these powers with a mala fide intention, that is with a bad intention, then it can be questioned in the court. That is, it can come under the judicial review if the governor exercises his power with a mala fide intention. So, ladies and gentlemen, moving on to another important question here. As per section 124A of the IPC, an individual has committed the offence of sedition if he or she, by words either spoken or written, brings or attempts to bring into hatred or contempt or attempts to excite disaffection towards the government, country, constitution, legislature and judiciary. Select the correct answer using the code given below. Option A 1 only, option B 1, 3 and 4, option C 2 only, option D 1, 2, 3 and 4. I'm giving you 30 seconds of the time to answer this question. Guys, here the answer is A, that is 1 only. So what is sedition? Sedition is a term which says that if you speak anything against the government, then you would be put behind the bars. You will have to criticize the government for sure, but that will have to be the constructive criticism which you have to do, not the destructive criticism. If you ever call any government an illegitimate government or a corrupted government vaguely, then you would be put behind the bars. So you shouldn't make any comments against the government, though you do have the freedom to do so. So here section 124A has been the British legacy. It had been passed by the British Parliament at that time, right after the independence. India had continued this particular section, which is considered as draconian section, which would curtail the freedom of individuals. So here section 124A of IPC says that whoever by words either spoken or written or by signs or by visible representation or otherwise brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may be added, or with fine. This is one of the tough questions. Couple of people have answered it well. Thank you so much. So moving on to another important question. Described by Dr. Ambedkar as the very soul and very heart of the Constitution, it is the preamble, right to freedom, that is protection of life and personal liberty, right to constitutional remedies and directive principles of state policy. Please do answer this question. Here the answer is C, ladies and gentlemen, that is right to constitutional remedies, because Article 32 says that right to constitutional remedies, that is to enforce the fundamental rights of the aggrieved person. So if at all the state violates any of the fundamental rights of the citizens of the country, then they can approach the court to enforce their fundamental rights, which is mentioned under Article 32. So here Dr. B.R. Ambedkar, the drafting committee chairman, said that it is heart and soul because right to enforce a fundamental right itself is a fundamental right. Hence, it has made the fundamental rights a real-time event. So, hence, Article 32 has been considered as very heart and very soul of the Constitution. Hence, the answer is C. So, Article 32 confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. In other words, the right to get the fundamental rights protected is in itself a fundamental right. This makes the fundamental rights real. That is why Dr. B.R. Ambedkar called Article 32 as the most important article of the Constitution, an article without which the Constitution would be nullity. Because if the state has the authority to violate the fundamental rights of the citizen, then the Constitution would be of no use. So it is the very heart and soul of the Constitution, and the Supreme Court has ruled that Article 32 is a basic feature of the Constitution. I would ask you a question here. The basic feature or the basic structure has been outlined in which of the case by the Supreme Court of India? Please do mention that case which outlines the basic structure of the Constitution. So hence it cannot be abridged or taken away even by way of an amendment to the Constitution. So moving on to another important question. Major obstacles to national integration with reference to India does not include regionalism, casteism, linguism, and none of the above. Please do write down your answer in the comment box. So here the answer is D, ladies and gentlemen, because these three are considered to be the obstacles to the national integration. So let us look at each term in detail here. So regionalism refers to subnationalism and subterritorial. It implies the love for a particular region or state in reference to the country as a whole. There is also sub-regionalism, that is love for a particular region in preference to the state of which the region forms a part. Coming to the communalism, it is relating to the religion. One religion says that they are superior than the other religion. Coming to the casteism, in which one caste says or establish their superiority over the other caste. Coming to the linguism, in which one community says that their language is more superior than other language. Take for example, Tamilian says that Tamil language is more superior over the Hindi. So here that is called as linguism. So moving on to another important question. As a leader of the house in a state legislature, the chief minister has power to advise the governor with regard to summoning and proroguing of the sessions of the state legislature, recommended the dissolution of the legislative assembly to the governor at any time, announce government policies on the floor of the house, select the correct answer using the code given below. Option A 1 and 2, option B 2 and 3, option C 1 and 3 only, option D 1, 2 and 3. I'm giving you 30 seconds of the time. Please do let me know the answer. Here the answer is D, ladies and gentlemen. That is That is, all of the above statements are absolutely correct, and this particular question has been asked in the backdrop of the dissolution of Telangana Assembly. So moving on to another important question. The Constitution provides for the abolition or creation of legislative council in states. Accordingly, the Parliament can abolish a legislative council or create it if the legislative assembly of the concerned state passes a resolution to that effect. In this context, consider the following statements. Such a specific resolution must be passed by the state assembly by a special majority. The act of parliament is not to be deemed as amendment of the constitution for the purpose of article 368 and is passed by simple majority. Which of the following statement given above are correct? Option A 1 only, option B 2 only, option C both 1 and 2, and option D neither 1 nor 2. Here the answer is C, ladies and gentlemen. Okay, moving on to the explanation. This act of parliament is not to be deemed as an amendment of the constitution for the purpose of article 368, and it is passed like an ordinary piece of legislation by simple majority of the house. Coming to the term special majority, a majority of the total membership of the assembly and a majority of not less than 2/3 of the members of the assembly present and voting. So ladies and gentlemen, with this we come to the end of this particular session. So ladies and gentlemen, if you do have any doubts, please do write down in the comment box. By that I would solve those doubts. So ladies and gentlemen, you can enroll in Unacademy Plus course by paying some amount of money. Please do use referral code as Rangu Satish 1947 to get 10% of discount. So you can access the free videos on Unacademy Learning app. Install Unacademy Learning app and search my name Rangu Satish, where you can access more than 1500 videos in relation to UPSC CSE, which are of free of cost. Please do access it. By that you can strengthen your preparation. So ladies and gentlemen, thank you so much for joining me on this platform. Thank you so much for being with me in this live session. It's been a great honor to get associated with the serious aspirants like you. Thank you so much.